Hi, I'm Steve Murphy, and this is the Insider Exclusive. Today we go inside the world of investors in justice right here in our American court system. Stay tuned to see how 3,000 investors and their $600 million are being denied justice. From 1989 to 1996, 3,000 investors invested more than $800 million in a company called USA Mortgage. And they stand to lose that money today. And today I have with me Donna Cangelosi, who is the head of an investors group, and her appellate attorney, Bill Cohan. Welcome to the show.
Thank you.
Donna, this is a long, convoluted story. But start from the beginning, explain to our audience, exactly what's going on here.
Well, our story started just about 3 years ago on April 13th, 2006, when the mortgage originator, who was basically placing mortgages on behalf of 3,000 direct lenders, as we call ourselves, went into bankruptcy. At that particular point in time, we were puzzled as to how a mortgage originator could go into bankruptcy. But ultimately, as the bankruptcy proceeded, we found out that there was a variety of different nefarious activities that had occurred.
Right, and let me stop you here for a second, because I want to correct one thing. It was from 1989 through 2006.
That's correct.
That 3,000 elderly people invested.
Yes.
You were one of those investors.
I was one of those investors, and as a matter of fact, I was responsible for not only bringing my own money into it, but I had such good experience with USA Capital that I brought many friends and relatives into this.
And they were a company that had been in business for, what, 20 years?
Since at the point that I had invested, they had been in business for 13 years.
Okay, and they had a stellar record.
Stellar record.
They paid, people bought trust deeds, right? They got paid the interest, they got paid their principal back, so that was a big reason, that was an important reason why people invested.
It was a very important reason. There was no blemishes against their record.
So USA Commercial Mortgage goes bankrupt.
They went bankrupt.
Okay, now what happens?
So what happened was we had a trustee put on us, or actually there was a trustee that was brought in as part of the bankruptcy. It was already prearranged in USA Commercial Mortgage. We went into bankruptcy court, and as the bankruptcy started unfolding, we found out that there was all sorts of, as I said, nefarious activities that had occurred. Loans
by whom?
By USA Commercial Mortgage principals, who had now been removed by the trustee.
Right.
Loans had been underfunded, even though the money had been collected. Loans that had been repaid had been used, instead of to pay back the original investors, had been used to pay out interest payments on defaulted loans that were non-performing.
Now, this sounds kind of like a Ponzi scheme.
It was a back-end Ponzi-like scheme, but in the beginning, all of our names went on trust deeds. And there could be, on an average trust deed, USA Commercial Mortgage was an aggregator.
Right.
And so there could be 150 strangers, direct lender strangers, that put in anywhere between $50,000 and $50,000 on up on a specific project. We had about 100 loans.
Right, and they lent it actually to USA Commercial Mortgage, which in turn loaned the money out to developers.
Well,
right?
What we did is they acted as a broker. Our money went into a trust account, and then they would close the loan, and then we would get a trust deed back. We had a deed of trust and a promissory.
And that's important to bring out, because as investors, you didn't buy stock, you didn't buy, bonds. You were actually on the deed, weren't you?
That's correct. Our name was on the deed of trust. So we were a secured investor.
Now
That's why they were called direct lenders, Steve.
Right.
Because they actually gave the money to USA Capital to loan to people who were doing real estate projects. And after the loan was made as part of the process, each of the direct lenders had a mortgage representing the amount they had loaned. So they thought if there were a problem with non-payment of the loan, they as direct lenders could foreclose on the property and take it over and manage it and protect their investment. But during this bankruptcy, some other things happened. Please continue, Donna.
So what happened is, as we proceeded into the bankruptcy, we had this huge parade of professionals that came into this bankruptcy. My own personal opinion is I think in 2006, the bankruptcy business was very slow. So therefore, because the economy was booming. So therefore, we had this huge parade of professionals coming in and creating...
Approved by the court.
Approved by the court, creating this massive amount of fees. Just absolutely massive amount of fees.
I think it was 40 million.
We ended up with $40 million in bankruptcy fees and professional fees against a company that actually had only $10 million of assets. USA Commercial Mortgage only assets was in originating and brokering loans. They had no other assets.
So kind of in a way, they had a lot of trust deeds under their control, correct?
That's correct.
Kind of in a way, they knew they didn't have enough money to pay them, so now they're looking at an asset to pay them. And the assets are owned by the direct lenders. You guys, 3,000 investors, right?
That's correct.
What happens next?
So they came up with a scheme by which if you had stolen principal and you also had money that was paid out to you to cover up that stolen principal for what they call an interest payment, a regularly scheduled interest payment against your loan, they called that prepaid interest. We had to return back the prepaid interest into the bankruptcy estate, and they made that an asset of the estate. There was about $40 million in prepaid interest that was going to come back into the estate from the direct lenders that were basically those payments were used to defraud the direct lenders.
Bingo, they got their money.
That's right. It was used to defraud the direct lenders because the USA Commercial Mortgage principals did not want to come forward and say, hey, we have non-performing loans here.
This is called robbing Peter to pay Paul.
Yeah, but by the court system. This is all happening under the supervision of the bankruptcy trustee, correct?
It's all happening under the supervision of the U.S. trustee, the bankruptcy trustee, and the bankruptcy judge. So what happened was there was 3 plans, bankruptcy plans, that were put in place.
And this, by the way, what year is this happening?
This is still in 2000. This is now 2006 still. Okay. There was 3 bankruptcy plans that were put in place. Each one got worse for the direct lenders. And by the 3rd bankruptcy plan, which basically took the prepaid interest from one pocket and put it into the estate and kept it for the professional fees, and we got nothing back in the other pocket, that was when I came forward and started objecting.
And this was in 2006?
Still 2006. It was
So in other words, the court is not recognizing that you are actually the trust deed holders, correct?
That's correct.
And they're just totally ignoring that. They're paying the professionals, by the way, they're paying the professionals to do what? What are these fees for?
Well, we had about $12 million in forensic accounting, whereby they did cash tracing for every single loan payment coming in and every single loan payment going out.
Yeah.
So there was about $12 million in accounting, and there was just runaway professional fees.
Okay.
All of the professional fees were unchecked. At every single hearing, we would probably have no less than 20 attorneys
Let me
at
suggest,
$400 to $500 an hour or more.
if I may respond to your question, there were some real problems that had to be solved. In other words, the money that had been robbed from Peter to pay Paul had to be traced, and that required a lot of accounting to figure out where it came from, to send it to people to whom it was entitled. And then there were legal issues. But Ms. Cangelosi clearly identified some terrible abuse that the bankruptcy court allowed to take place at the expense of the direct lenders.
Now, when you say you came into the picture, what did you do?
I had been already communicating with many people because of I felt responsible. I had essentially brought in, tens of millions of dollars of investment through my experience into USA Commercial Mortgage, and I felt responsible. So what had happened is I had been going to the bankruptcy proceedings, and I had been communicating, putting out a little email communication with other direct lenders who I had been connected with. This was a networking type of business where if you invested and you had a good experience, you told me, I told Bill, and then before we knew it, a network grew. So through this communication chain that I had set up early on in the bankruptcy, very early on in the bankruptcy, I was now probably communicating with 600 investors, people I didn't know, I had never known. What happened was when we saw the bankruptcy plan change significantly, that all of a sudden took our interest payments that had been made against to defraud us against non-performing loans, and it was taken, and it was supposed to be paid to us back for our stolen principal. I had $180,000 in stolen principal, and instead of that money coming over to me and being offset, if you will, it was going into the USA Commercial Estate so the professionals could have at it, and I was going to end up with zero. I started organizing a group to raise a legal fund in order to be able to fight that.
And the name of this group?
The name of the group was called the Lenders Protection Group.
Okay.
But what Donna did that she hasn't told you specifically is that she organized people to look after each loan. Just to remember now, we had, by this time, by later on in 2006, there were roughly 70 different pieces of property on which different groups of direct lenders had loaned money. So each one of those loans had separate issues with respect to that loan. The non-payment, the late payment, the diversion of funds, the accounting that needed to be done, some of which was simpler when you only had maybe 25 or 30 people loaning, as opposed to a loan where maybe 200 people had loaned money on a bigger project. Donna got the communication set up for every one of those projects, and she also made arrangements to turn these groups of people into organized entities called limited liability companies.
And you did that for protection?
That was subsequently down the road, yes.
You did that for protection?
We did that
so
for protection.
Their ultimate maximum loss would only be the investment that they had?
That's correct. Because at that particular point in time, well, ultimately, when we set up the limited liability companies, we were concerned over two things. We were concerned over the future actions that happened to us after the bankruptcy closed. And we were also concerned over lender liability lawsuits.
Yes.
Because we had loans that were short funded. As a matter of fact, you'll speak with a borrower today who will tell you the story.
Okay, now, it went from bankruptcy court to the federal court it's in right now, correct?
That's correct.
What was the transition there?
Well, what happened was the bankruptcy plan, part of the assets of USA Commercial Mortgaging was the loan servicing of these portfolio of loans. Lenders had a loan servicing agreement with USA Commercial Mortgage, and that loan servicing agreement was considered an asset of the bankruptcy. The bankruptcy decided in order to raise more money that they would sell the loan servicing rights to that particular portfolio of loans.
And let me explain that what the loan servicing meant was that USA Capital was supposed to collect the payments every month and then distribute those payments to the direct lenders, for which they received anywhere from 1% to 4% of the amount collected. Well, if you take $800 million and you're getting payments on that, and let's say it's $8 million a year, then 1% of that would be $80,000. Well, what happened was the bidder got the right to service the loans. But the direct lenders had the legal right to say, we don't want you servicing our loans. This is where the dispute became a catastrophe in district court.
Right. Bankruptcy court approves the sale of the servicing element of USA Commercial Mortgage, right?
Exactly.
That's correct.
It is sold to whom?
It's sold to first off, let me explain to you, the servicing of commercial mortgage loans is a highly specialized business.
Okay.
It's rated, it's tracked and rated by premier organizations such as Standard & Poor's and Fitch, and they rate loan servicers. Rather than bringing in a rated loan servicer for already people who have been financially devastated and giving them pros, what they do is they bring in a company called Compass Financial Partners, which was an assetless shell set up basically a month before the bankruptcy auction by two partners, Len Mezzi and Jake Cohan. It was set up for the intent purpose of buying these assets. Compass Financial Partners, as I said, this unrated, no experience, assetless shell.
Yeah, usually in these situations, the bankruptcy trustee is the one who recommends something to the judge.
That's correct.
And that's what probably happened, and the judge approved it.
The judge approved it. However, on the eve, what was interesting in this, Steve, is on the eve of the auction, the asset purchase agreement, which we had approved, changed dramatically without disclosure to the lenders. So what happened was and when we raised that issue at the bankruptcy auction in court, we were told by the judge to sit down and shut up.
You were told by the bankruptcy judge?
By the bankruptcy judge to sit down and shut up. We said, Your Honor, we feel that these terms that it's being changed to is egregious to the direct lenders. We raise our concerns, and
What did she say exactly?
She basically said, please sit down and be quiet. If you want to raise your concerns, do so in an appeal.
Okay, and her name was?
Judge Linda Regal.
Okay, now, it gets sold, the servicing element gets sold to Compass.
Compass.
Okay, the bankruptcy closes.
Correct.
Okay, now, how does it end up in federal court?
Okay, it ends up in federal court that prior to the closing of the bankruptcy, or prior to the auction, I had a call from, if you will, a whistleblower, who was a former, not employee, but he was a former consultant to Compass and had helped evaluate the portfolio. He called me, and his first words to me are, you guys are going to get screwed.
Okay.
And I said, why? He said, because Compass Partners is going to buy this portfolio, and their plan is to take fees that the loans generate that are granted in our loan servicing agreement as incentive compensation to quickly collect defaulted loans. They're going to take these fees, and their position is that whether they're collected from the borrower or they're collected from you, they're going to get these fees.
How did it get in federal court?
The legal dispute was whether the loan servicer, the successor who bought Compass in this case, could collect the default and late fees from the direct lender's portion of this loan. And the loan servicing agreements do not provide for that.
So-
They provide that Compass, or USA Capital, its predecessor, could only collect late and default fees from the borrowers who are late. The problem is, of course, that the real estate market began to decline, so there weren't going to be any fees collected from the borrowers. They were in default.
Right.
The issue was whether and to what degree the direct lenders could get all of their principal or most of their principal and not even get the interest that they were hoping to get in many cases. But what the purchasers, Compass, and really the people who funded it are Sylar advisors, and this is the essence of the dispute in federal court, took the position that, oh no, we could take late fees and default fees right out of the principals loaned by the direct lenders and take all of the money the longer it was in default. And so they not only had no incentive to clean up this mess and get these direct lenders as much money as possible,
But
as
to
quickly
drag
as
it on.
possible. The more it was dragged out, the longer it took, the more they said they could claim to take away from the direct lenders who were owed their principal back.
So you, as a group, went into federal court,
We went into federal court.
sued Compass.
Correct.
Actually, the LLCs,
Yeah.
which had acquired the interests of most of the direct lenders who pooled their resources
Yeah.
on each one of these loans, the LLCs came in, and the LLCs filed suit, which leads to one of the big problems that happened in federal
And
court.
interesting enough, we're going to have some of these investors on this show today. I want to introduce my first two guest investors in this nightmare investment. Daniel Newman
How are you?
and Frida. Thank you for coming here. I'm going to ask both of you some questions, and basically is, what did you do? You're retired, both of you, obviously, right?
Yes.
Frida, you're what, 99 years old?
Yes.
It's amazing. And you're a youngster, right? 76?
Right.
What did you do when you were working? What type of profession?
I was an aerospace engineer.
So obviously you're an educated person. You make good decisions about your investments. How much money did you invest in this investment?
I invested about $500,000 in USA Capital.
And why did you invest? They had a good track record,
They had an excellent track record.
and it was secured. It was a trust deed, right?
It was trust deeds. I owned the trust deeds. I wasn't investing in a fund. I wasn't investing in stock.
You own trust deed on properties.
Trust deeds on property. So my loans were secured,
Okay.
and they were represented as being to deserving borrowers who had large financial worth and the ability to conduct the projects that they said they were going to
Yeah.
conduct.
Now we've just heard from Bill and Donna that this whole thing has turned into a catastrophe. Right now, it might look like you lost your money, $500,000, and you can't go out and get another job. How has this affected your life?
It's completely changed my lifestyle. I'm now living on Social Security. I'm having to watch my pennies. Fortunately, I haven't lost my home, but certainly I can't afford any luxuries.
How about your mother?
My mother is even in worse condition. She is legally blind. She is nearly deaf. She is living alone. She needs assistance. She cannot see to cook
How
or
much
to
money?
dress herself.
How much money did she lose?
She had about $300,000 invested.
Between you, 800,000, right?
Yes.
Okay.
She has no income, cannot afford to have people come in and give her the assistance that she needs in her home.
When this catastrophe first happened, USA went bankrupt. You thought for sure that your trustee would be secure, you'd get some money back or all of it or whatever, right?
Yes, I believed that our trustees were our property,
Okay.
not the property of the debtor, and therefore they would be excluded from the bankruptcy.
What is your opinion of what the court system is doing to you now?
The court system is raping us. The court system has no concern for us. The court system only has concern for protecting itself and each other.
Well, we hope with Bill and Donna's help that this is resolved successfully in your favor, and I want to thank you very much for coming here.
I thank you.
And thank you, Frida, very much for coming here, okay? I want to welcome my next guest, who also was an investor, Dr. Stanley Alexander. Welcome to the show.
It's my pleasure, sir.
You are a doctor you have a doctorate in education.
Yes.
Well-educated man, invested your money in a company that was a good company, correct?
That's correct.
What do you think about what the court system today is doing to all the investors?
My opinion of the court system that it has no knowledge of the law that they're supposed to represent the people.
And it doesn't want to have knowledge either, does it?
Yes. They have abused their power and have taken advantage of what they perceive to be people who did not have enough sense because they were old people. And as the judge would say from the bench, I have absolute immunity.
He said that?
He said that.
Wow. Well, we wish you much success in recovering your money. I know Bill and Donna are going to do that for you. My next guest, another investor, is Gene Weehee. Welcome to the show.
Thank you.
Another story of someone who invested a lot of money. How much money did you invest?
Well, I think about 175 at any one time.
Yeah. And you had, in the beginning, you had good returns. You had,
Yes.
you felt secure. But now some of that money or all that money is in jeopardy, isn't it?
You know, the first 4 loans went through okay and paid off and, like agreed to, and then the last 2 were,
Right.
one is for 75 and one was for 50,000.
It's one thing for a company to go out of business. It's another thing when the court system doesn't give a damn about the investors, isn't it?
Yes.
What's your opinion on that?
Well, they don't give a damn about the investors. That's
And
for
why
sure.
is that, do you think?
They were crooks.
Yeah. The court system too?
Oh, yeah. Well, the court system doesn't favor the innocent.
Yeah.
In my estimation.
Well, you know, I want to thank you for coming here today because, you know, I think Bill and Donna are going to do something positive. At least we get a good reading in the Ninth Circuit. Okay.
Well, Donna has been our angel.
Okay. Well, thank you for coming. We wish you much success.
Thank you.
I am pleased to have 2 more people on the show. One's an unusual person in the sense that Abel Godinez. Welcome to the show.
Thank you.
You're a borrower, aren't you?
Yes.
You actually borrowed this money from USA Capital,
Yes.
right? And Carol Kessler, correct?
Yes, that's
and
correct.
you're an investor.
Yes,
Welcome to the
I
show.
am. Thank you.
You have a kind of an unusual story. You went to pay the money back
Right,
to USA Commercial Mortgage, right?
correct.
And they refused your money, correct?
Compass Partners refused the money.
From my understanding, what was your original loan amount?
The original loan amount was $12.9 million.
And you agreed, you negotiated the amount of money with the bankruptcy trustee, was it?
With the bankruptcy trustee, the
To
creditor
pay-
committees, and
To
the
pay $9 million back.
$9.5 million.
Done, settled, everything.
Correct.
Okay. The servicing gets sold to Compass, correct?
Correct.
You go to Compass with your $9 million.
Right.
They refuse it, right?
Correct.
What'd they tell you?
They said that they didn't want to take the money because they would make no money if I paid off.
On the $9 million.
Right.
What did they want?
They wanted something on the order of $18 million.
So where's the money now?
The money was a refinance through another institution to refinance and pay off the loan.
Okay.
So when they refused the money, that refinance went away.
Okay. All right. So you were refinancing your loan to pay it off and be done with it. They wouldn't take it, correct?
Right. They said specifically, if we don't make any money, we don't care if the project burns.
They said those exact words?
I have it on tape.
Carol, you're an
Yes.
investor.
Yes.
What do you do for a living?
Right now, I'm actually a retired international flight attendant for American Airlines.
So you worked hard all your life.
Yes.
You took how much money and invested with this?
I invested over $200,000,
200,000. And now it looks like you may lose all that, correct?
the majority of it, yes.
Currently, this case is on appeal to the Ninth Circuit, and Bill Cohan is handling that for you. He's one of the lawyers handling it for you.
Yes.
What do you know, this is probably your first experience with the court system. What's your opinion of what Judge Jones is doing to all the investors?
Well, I feel that our rights have been violated. He was a former bankruptcy judge.
Yeah.
And he seems to be looking at this from the bankruptcy terms and being sure that Compass Partners gets what they bought and paid for, and he just doesn't seem to be at all concerned about the direct lenders and everything that has happened to us with all of the money that we've lost.
Wow.
And he's trampled on our rights in that we're not able to go out and protect our property.
Well, Bill and Don are going to make sure that that doesn't happen, okay? That you do recover your money, all right? And hopefully you'll get another judge, and we wish you a lot of success in
Thank
doing
you.
that. And thank you for coming on the show, Abel, okay? I've just never heard of an institution refusing money, especially when it's already been negotiated, but this will work out. This is a travesty of justice, and these people that we have just witnessed, they put their heart and their soul, they believed in this. The judge has basically knocked their feet right underneath them. Bill, where do you go here?
We're in the Court of Appeals seeking relief from the appellate court to reverse what the judge has done and get us a judge who can hear and adjudicate the issues that should have been decided 2 years ago. Namely, who is entitled to what and in what order, rather than trying to crush these people, primarily their spokesperson, Donna, to prevent them from even asserting their rights. If we're successful in the Court of Appeals, we will get a chance to actually litigate these disputes and the claims these direct lenders have to get their principal back and to sue the people that have ripped them off.
Well, we wish you much success. And Bill, how can folks get a hold of you?
Well, they can call my office at area code 858-832-1632.
Do you have a website?
I do. It's www.williamacohan.com.
And that's Cohan, C-O-H-A-N.
Yeah,
Okay,
correct.
.com. And Donna and Bill, thank you for being on the show, and we wish you much success.
Thank you, Steve.
Thank you. Thank you for watching. You can get more information about our guest and the issues at insiderexclusive.tv. Come back again.